Or do we need to reopen court?
Yes, Your Honor.
Mr. Soares, excuse me.
Yeah.
The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court.
Thank you very much, Mr. Clerk. And thank everyone for participating in this virtual oral argument here at the Court of Appeals of North Carolina. We have one case remaining on the oral calendar, and that is the North Carolina Department of State Treasurer Retirement Systems Division versus Laura Riddick. And your panel for hearing this afternoon is Judge Tyson, Judge Collins, and myself. I'm Judge Bryant. And we will now hear from the first appellant, their cross appeals. So we'll hear from the Riddick appellant, and each side does have 30 minutes total. Thank you.
Thank you, Your Honor. May it please the court, I'm Bob Orr, along with my co-counsel, Joe Zazatarski, who is here with me to my left. We are here on behalf of Laura Riddick. I believe I reserved 6 minutes for rebuttal.
Okay.
Unless the court needs me to recite the facts, I think they're essentially undisputed, and I will incorporate those as needed in the argument to the court.
That sounds great.
Let me begin by what I have delineated as the threshold issue. And this is whether the statute relied upon by the system to impose a forfeiture of retirement benefits rights on Ms. Riddick was met in this case. And I say a threshold issue because if the court agrees with our arguments that this statute was not met, then all of the other issues involving statutory interpretation and the constitutional issues raised in this case need not be considered. And our argument essentially is that when Session Law 2012-193 was enacted and created a statutory provision, 128-38.4A, it specified a very specific set of circumstances and way to go about determining whether the forfeiture statute should be imposed. And I think to properly understand our argument, you have to look at pre-2012, when 128-38.4 was the only forfeiture statute on the book. And that statute was very narrow. It only applied to public officials, and it specifically delineated felonies under federal or state law, which would trigger the forfeiture provisions. In 2012, when the Session Law was enacted, the General Assembly exponentially expanded the coverage and scope of the forfeiture laws to deal not just with public officials, but literally with every single individual in any of the myriad retirement systems under the umbrella state retirement system. Teachers, deputy sheriffs, court officials, legislators, all were now covered or potentially implicated in the forfeiture statute. In addition, as opposed to what was the scheme in 38.4, 38.4A delineated absolutely no specific felonies. And so at least at that point, every conceivable felony on the books was in play when it came to the forfeiture. The General Assembly set out a very specific scheme, however, to narrow the scope of this coverage. And in doing so, it added in the Session Law an amendment to the aggravating factor statute D9, and they also made a specific provision when an individual was going to be charged with a felony that implicated the forfeiture statute. And so the way it worked was that the individual charged had to be a member in service at the time of the felony. And secondly, the felony, the conduct, had to be directly related to the office or employment. And so the General Assembly set up a very specific statutory framework for that question to be answered. And in doing so, it's in provision A2 of 38.4A. And what it says is subdivision 2 of subsection A of this section shall apply to felony convictions where the court finds under GS 15A-1340.16 D9 or other applicable state or federal procedure that the member's conduct is directly related to the member's office or employment. And so the requirement was that the trial court presiding over the felony trial would make this determination. If you think about it,
I jump in for a second on this. I can't see you on my screen. I don't know if anybody else has that, but I can certainly hear you, so I am fine. So I'm going to go ahead and talk. My question on D, that it says where the court finds, and it's talking about that aggravating factor under D9. Any reason why they would say the court finds when a court can't find an aggravating factor, the jury has to, or the defendant has to admit to it? Is that just a poorly worded, or is there some significance to that?
You know, in all due respect to the General Assembly, Judge Collins, none of these statutes we're dealing with are particularly well written. But I think what they were attempting to do is that if you're going to find this specific factual connection, that somebody has to make that decision. Now, the system says, oh, we get to do it. But, you know, one, they're not listed in the statute. And two, the General Assembly says that it's the court. And the court's in the best position to do this because it's presiding over the trial. And and one of the interesting things about this whole circumstance is that the session law in creating this scheme requires the district attorney in the indictment to put the defendant on notice that, in fact, they will attempt to prove the aggravator. And in this case, that's exactly what happened. So, you know, the district attorney's office was on notice, the trial court was on notice, arguably the system was on notice, the defendant was on notice that the aggravator was at issue in regard to the forfeiture statute, and the trial court, in its judgment, did not find the D9 aggravator.
Mr. Moore, is there anything in the legislative history to determine why it was that the legislature just put that aggravating factor in and not the fact that the member is in service? It seems to me those are the two specific things that have to be found if there's a felony. I wonder if there's any explanation for why the General Assembly would do one and not the other, since both of them are necessary prongs to the forfeiture.
Well, Your Honor, I don't think there's anything in the legislative history. I think as a practical matter, the statute, the 38.4A amendment in 2012, was so incredibly broad that they had to come up with some means of narrowing it down to see whether the forfeiture statute should be applied. And I think we used the example in our brief of, you know, a state official going to a continuing legal education program put on by the Clerks Association and goes to happy hour, drinks too much, has an accident, ends up getting convicted of a felony. Now, was the conduct related to the officer duty? You know, some people might say, yes, it was. They were down there speaking to the group. They may say, no, this was a social event outside the scope. So the legislative scheme, it seems to me, even though there's no specific legislative history, is to provide the court, a definitive decision or definitive mechanism to make this decision. And so, I mean, there certainly, if the General Assembly wanted to make the system responsible for this this finding, they could have written legislation very easily that said that, or anybody else. But
Mr. Orr, let me ask you this: your client entered guilty pleas, six pleas to 1492, which is embezzlement by a public official in excess of $100,000. So all of the elements that felony could only apply to acts of a public official, period. So I don't understand why some additional finding of being related to the office is when the only way your client could have been convicted of this particular statute of 14-92 is that she was, in fact, a public official and she embezzled public funds in excess of $100,000 on 6 counts. So why is the aggravator even relevant on a guilty plea? Judge Collins said, it must be found by the jury. There was no jury there. Your client pled guilty to a precise felony that were only an elected official stealing more than $100,000, could be convicted on that statute.
Well, first of all, if the General Assembly had wanted to specifically set out in 38(4)A certain crimes that would automatically implicate the forfeiture statute, they could have done it. They've done it in other statutes for whatever reason. And I can't speak for the General Assembly. They set up a particular scheme that requires the aggravator. And, while this may be terrible legislation, it's not to the court to rewrite the statute in a more reasonable fashion if this is what the General Assembly did. And
so, Mr. Orr, what would you do with the fact that they removed subsection B altogether, the General Assembly, and clarified this so that hanging chad, so to speak, is not even necessary any longer? Consider that.
Well, Your Honor, they did, and I would submit, one, it has no particular relevance other than the fact that the clear answer that the system argues for obviously wasn't clear, and they have changed the statute now, but it doesn't apply to our case. I mean, it's a situation where the General Assembly made a decision. Was it a good one? I can't answer that. All I know is they did not, in this case, they did not comply with it. And I
want to go back to my question, though. The specific element of the 6 offenses your client pled guilty to can only apply to a public official who embezzles in excess of $100,000. Those are essential elements of that offense. It wouldn't apply to a private individual. It probably wouldn't even apply to a public employee. I mean, doesn't the elements of what she pled guilty to, isn't that pertinent to whether or not, she would be subject to forfeiture for that felony?
If it is pertinent, Judge Tyson, then the General Assembly should have written the statute that way. They didn't. They didn't. They could have very easily said 1492 automatic forfeiture if you're a public official and you do this in the scope of your work. That's not what they did here. And because I've lost the visual connection and I'm on my phone using the audio, I've I've not been able to keep up very effectively with the time I have, but I'm way past and with where I need to move on to two quick
You've got
issues.
16 minutes.
Yeah, well, is it all right with the court if I then move to the other two issues that I would like to address? All right. Secondly, if the court disagrees with our threshold argument and the constitutional implications in this case, the system attempts to take away completely the 6 years and 2 months that Ms. Riddick earned, accrued, and had vested in the teachers and state employees system. And then pursuant to the statute 128-34, which says any member of the local government employment retirement system shall be entitled prior to retirement to transfer to this retirement system his credits for membership in prior service in the teachers and state employees system. That's exactly what she did. It was approved. It was time that had been accrued, invested, and the system's argument is because it was added right before retirement and after Session Law 2012 was 193 was passed in the December 1, 2012 timeframe, that she loses that. She loses it completely. Can't even pay it back to the TASER system and retire there. So one, the system's attenuated argument about what constitutes accrual, there is no definition in the statutes, is wrong. It flies directly in the face of 128-34 and the transfer of that time. And therefore, as the administrative law judge and the Superior Court judge found, Ms. Riddick was entitled to that time, and it should not be forfeited, as argued by the system. And secondly, even though it's not the exact statute, 128-38.4 has a specific provision, and this is a statute that deals exclusively with public officials. It says, no member shall forfeit any benefit or credible service earned from a position not as an elected government official. And that's exactly what the system is arguing should take place here, simply because they have proceeded under 38.4A as opposed to 38.4. And so for that reason, the 6 years and 2 months that Ms. Riddick earned and had vested working for cultural resources, and which was transferred pursuant to statute, should not be forfeited. Essentially, the second argument the state has on the accrual issues is that she loses 2 years, 7 months of earned sick leave that she did not use. It's essentially the same argument that because it was converted at the time of retirement, she loses it, but we would submit that all of this time had been earned and accrued on a daily basis, and the system admits that in their brief. And the third area of accrued time that they say she loses, the time after December 1, 2012, while she was still working as a register of deeds, and we would rely on our constitutional arguments as grounds why they cannot prevail on losing that time. And finally,
can I jump in with a question on the sick leave?
Yes.
It seems that the sick leave is perhaps a different type of conversion than the accrued time working, because that sick leave does not, in fact, convert into retirement benefits until the exact date you retire. Up until that date that you retire, it's leave that you can take, correct?
It is leave that she can take, and prior to whatever the magic minute where she is active 1 minute and retired the next. She went through the paper process with the system. It was converted into credible time as allowed by the statute. And so our argument would simply be that she is entitled to all of that time, or at worst, and this is what the ALJ and the trial court affirmed, is that she's at least entitled to accrued sick leave up to December 1, 2012, when the forfeiture statute was passed. So that would be our position on that, Judge Collins. Finally, the third issue, and I've got a couple of minutes to address that, is the Register of Deeds Supplemental Pension Fund, which Ms. Riddick was vested in and was drawing at the time that the system, shut off all of her retirement payments. And first of all, if you agree with us on the first issue, then you don't reach the Register of Deeds issue. But secondly, if you don't agree with us, then I would reference Session Law 2018-84, which literally was passed about 2 weeks before Ms. Riddick pled guilty, and attempted to make a number of changes in the taser forfeiture statute and the 128-38.4 statute, adding a variety of felonies. It included in Section 2C the provision that a county register of deeds who is otherwise eligible to receive a monthly pension shall cease to be eligible upon forfeiture of any retirement benefits under either 38.4 or 38.4A. And again, this was passed 2 weeks before her guilty plea. In 2E in that session law, it says the section is effective when it becomes law, but where they have added these felonies, including the felonies under 38.4, it only applies where the offenses were committed on or after the date of this law. And our second argument on the Register of Deeds pension is that that under this late-breaking piece of legislation, the offenses occurred long before this act took place, and therefore the system's attempt to have Ms. Riddick forfeit the vested pension benefits under the Register of Deeds statute should fail. Now, the administrative law judge and the trial judge, in affirming the ALJ decision, said that she was entitled to all of and this is pursuant to Section 2E of that session law, that she was entitled to everything up to the date that the system sent her the letter saying you're no longer eligible. So there's sort of a gradation on this issue. One being, we think she's entitled, to all her benefits and her prospective benefits, but under the worst scenario, she would be entitled to the benefits she received up to the letter in September of 2018. And so with that, I will reserve whatever time I have left for rebuttal. Thank you.
I'm sorry, you have close to 7 minutes, so you're doing good. We'll hear from you, Ms. Murphy.
Thank you, Your Honor. May it please the court, I'm Catherine Murphy, representing the retirement system parties in these related appeals. I'd like to begin by emphasizing that there are two forfeiture statutes under elders. the one that was applied in this case is section 128-38.4A. It has a companion statute, 128-26, subsection X. And I say companion statute in the sense that the statute reads, subject to 128-26X, the retirement system shall pay no benefits, et cetera, et cetera. So those two statutes go together in terms of how the forfeiture works. And again, that's the forfeiture statute that was applied in this case. There's also another, the other forfeiture statute is 128-38.4, and it's got a companion statute, which is 128-26, subsection W. And those two apply in different contexts, but are also forfeiture statutes. And the
Are the first ones, I'm sorry, are the first statutes that you mentioned with X, the Tessers, and the second set, the L?
they're both of those sections are for Elgers. The
Okay.
128-38.4A is the actual forfeiture statute, but it says subject to section 128-26X. There are no, the member who commits a certain felony will forfeit benefits. And so you have to look at 128-26X in order to see what limitations are placed on this forfeiture. So those two go together, and those are the two sections together that were applied to forfeit Elgers benefits of Riddick.
I want to ask you about subsection B of 128-38.4A.
Yes.
The argument, obviously you heard the argument from the other side, but your argument is that it merely provides an example of a mechanism of the related to member's office, how that can be established, just merely an example. Why would they put one example in there?
I'm sorry, I wouldn't characterize it as an example. I would say it's more of a, in section A, the retirement system is told you need to make this determination. If A1 and A2 are both satisfied, no benefits should be paid subject to this other section. Subsection B says A2 is satisfied. A2 must be satisfied where the court has made the aggravating factor finding. So in a sense, so my argument is that it would limit the discretion that is given to the retirement system in Part A. When the aggravating factor is found, then you must find that A2 is satisfied. And the reason for that is because when the aggravating factor is found, as you know, that means a jury must have found beyond a reasonable doubt that the aggravating factor was applied. As either that or the defendant must have admitted to it. So you can be pretty confident in the case where the aggravating factor was found at sentencing that A2 is satisfied. And so we would not want the retirement system for some reason to make a different determination.
Ms. Murphy, part of the difficulty I'm having here, we got two different appeals from both sides simultaneously. You're defending the position that the retirement system took, that she's not entitled to anything. And in addition to that, we've got a Superior Court judge's order that is reviewing an administrative law judge's order that found facts. And the Superior Court is basically bound by the facts of the ALJ, just as we are. So part of the difficulty I'm having here is you're having to argue two things at one time. She's not entitled to anything, and even if she is not entitled to any more than what the Superior Court, the ALJ, gave her. Is that correct?
No, it's a little more complicated.
Well, let me go on from there. The trial court's order on appeal is presumed to be correct. And you and Mr. Orr have the burden to show error and prejudice, both. So I know what your original positions are on both sides, but the problem here is we've got a trial court's order before this court that is presumed to be correct and is based upon an ALJ who made the findings of fact. And those findings are not really contested. So I know we got two appeals. I know what the original position of both parties are, but What we're dealing with here is a Superior Court judge's order.
And I think where the what's before you now are not appeals of the factual findings. I think we do agree on the findings of fact that the ALJ made that were affirmed by the Superior Court.
Okay.
But what we disagree is the interpretations of law. And so, these are purely legal issues, which you review de novo. You're not bound by the legal determinations that the ALJ or the Superior Court made. We're here asking you to make a different legal conclusion, but based on the facts as the ALJ found them.
Right, but you would have to overcome the presumption of correctness that they erred in applying the law. That's still your burden.
Right. Then that's what I'm doing now is trying to convince you that they did err in their legal determinations about the consequences. Right.
Well, I want to, and it's hard to do on an argument like this, but I would like to have, I know there's one argument she's not entitled to anything, which is the original determination of the retirement system. Is that correct?
No, she is eligible. When she becomes eligible to retire, she will be entitled to receive a benefit. But what the retirement system determined was that through the forfeiture statute, she forfeited enough creditable service that she fell below the amount needed to retire when she did on an early retirement.
But I understand they also did more than that. They also refunded her contributions that she made and credited the value of those contributions toward a deficit that had been billed to her. Correct?
That's correct. Because when she was no longer eligible, because of the forfeiture, she was no longer eligible to retire. So she had an overpayment of the benefits that she had received. That became an overpayment. Now she didn't get back all of her contributions that she had put in. She got back the contributions that corresponded to the forfeited service. But yes, you're right. She had an overpayment because she had received retirement benefits that she was no longer eligible to receive after the forfeiture, but they were offset, that overpayment was offset by a refund of contributions associated with the forfeited time.
So do you agree that she is still a vested employee with more than 16 years of creditable service?
Our position is that following the forfeiture, she remained a vested employee. She has 16 years of service. When she becomes eligible to retire, she will be entitled to draw benefits based on those 16 years of creditable service.
At what age?
I'm sorry?
At 65 years old?
She could retire with an early benefit at age 60, or she could retire with a full benefit at age 65.
But it would be based upon presuming she doesn't go back into state employment. It would be frozen at that 16 years.
Correct. It would be frozen at the 16 years because part of the forfeiture is that you cannot earn service at all in the future. So even if she went back to work for the state or for a local government, she would not be able to earn additional service.
Okay, so
frozen.
There's really no dispute about the time that she earned at Cultural Resources. I mean, she still has that, correct?
Well, no, she voluntarily transferred that away from Teaser. She took it out of her Teaser's account, transferred it to her Elders account. So she no longer has a Teaser's account. And our position,
that was something she was allowed to do without losing that service, was she not?
Had she not committed the 6 felonies you mentioned earlier and been convicted of them, she would have been allowed. I mean, she certainly was allowed to transfer it from Teasers into Elders. But she lost it because she was convicted of the felonies, and in Elders, that time accrued after the December 1, 2012 date and became subject to forfeiture.
Okay, so if she had done that, let's say she had 6.5 years, and after being registered deeds 4 years, she had transferred that 6.5 years to have 10 years of vested service. Would she still have that 10 years?
I can't do the math in my head, but I think what you're asking is if she had transferred that over to Elders prior to December 2012, yes, she would have been. That would not have been subject to forfeiture from Elders if she had transferred it prior to December 1, 2012.
So the state's only claim to forfeit for prior service at Cultural Resources is the timing of when the transfer was made. Is that correct?
Exactly. The statute says that anything you cannot, and this is clearly the legislative intent, is to say if we're putting you on notice in July 2012, when this bill goes into effect, that if you commit and are convicted of felonies directly related to your service on or after December 1, 2012, you may not earn additional service. You may not increase your retirement benefits. Anything from December 1, 2012 onwards, you will lose. And that is what's going on. That's what's happening here. She transferred in order to increase her elders' retirement benefits, which per se, there's nothing wrong with that, but she transferred service. She grew 6 years of service towards an increased retirement.
Is she not entitled to the presumption of innocence until such time she pled guilty or was found guilty?
Yes, and this does not have anything to do with the criminal side of it. This is
No, the timing of it. I'm asking about the timing. Would
okay.
she be able to have transferred that service anytime up to being found guilty or pleading guilty?
The statute says if you are found guilty or plead guilty anytime after December 1, 2012, you lose the service from December 1, 2012.
So you're telling me if she'd left it where it was, or if she had transferred it earlier, she would have gotten the full benefit of those 6.5 years?
Yes, because they would not have become subject to forfeiture because the statute was prospective and it said we're only going to take, we're enacting the statute now and we're putting you on notice that come December 1, 2012, you stand, vulnerable if you commit and are convicted of felonies, you will lose your service. And so they would not take it prior to that date. So
Where's the error in the trial court's judgment? Is it in the application of the statutes? Is that what the state's position is?
That's correct. The ALJ found that because the time in teasers had accrued in teasers prior to 2012, that she should not forfeit that. And our position is she would not have forfeited had it remained in teasers. But by virtue of putting it into elders after December 1, 2012, it accrued in elders after December 1, 2012. And per the statute, it's forfeited. It's subject to forfeiture because it grew her retirement benefits in elders after the key date. And so
Was she vested in
Do you
teasers?
agree with Justice Orr that there's no definition for accrue in the statute?
There's no definition, so you would use a standard definition or a dictionary definition. You have to use it. You have to find a definition outside the statute because there's not one in the statute. And the definition I quoted in the retirement systems brief was something accrues when it comes to one as a gain, addition, or increment. So our position is it accrued in teasers, but when she voluntarily transferred it over to elders, it accrued in elders at the time of the transfer. It became an addition to her elders account. It increased her elders retirement benefits at the time it was transferred into her elders account.
At the time she transferred it, was the 6.5 years in teasers, was she vested or was there a 10-year vesting at that time? Was it 5 years or 10 years to vest?
It was 5 years at that time.
So the state acknowledges that she was vested in teasers with 6.5 years of credited service.
She was vested in teasers, but the one can voluntarily relinquish one's vested rights, and that's what one does when one requests a refund of contributions, and that's also what one does when one transfers the service out of the teasers account and into another account.
So you can lose the vested right?
Yes, you can. Yes.
By transfer?
I'm sorry, what was the?
By transfer.
By transfer, and it says that in the statute, and it says that on the form you sign when you effect your transfers. That I understand that I am giving up any right to any benefit in teasers.
Okay, thank you.
Yeah.
So is that the only situation in which accounts can be accrued 2 times? Because you've got accrual in teasers, and then you've got accrued in LSERS, and the second accrued is the one in which you're saying it should be totally forfeited, as opposed to, I assume, I shouldn't do that, but that the ALJ was looking at the accrual that occurred the first time in teasers when she was a regular state employee.
Right. I believe the ALJ's analysis, which we contend was an error, was to look at only the fact that it had accrued in teasers And I think, people are aware that when, that you can vest in the retirement system. And so she was, I think, sidetracked by the fact that when Riddick earned her 5 years in teasers, she then vested, and then she had some rights to a retirement benefit based on these 6 years. But what the ALJ, I think, overlooked was the fact that that was a right in teasers. She could have forfeited in teasers if the timing had been right. I mean, there's a teaser forfeiture statute as well. But what, even though it had accrued once in teasers, the reason it became subject to forfeiture was that she then moved it over to elders. And the elders forfeiture statute says you forfeit all creditable service that accrues after December 1, 2012. And when she moved it, it accrued in elders at the time of the transfer. So it's not so much that there were two accruals, or I think the confusion comes in the fact that there were two different systems. The systems are separate. And if you would just sort of view it as one big retirement system, sure, it would accrue one time when you were in service. But because these are two separate systems, something that has accrued or vested in teasers has nothing to do with elders. When you move it over to elders, which is your right because there's a statute that says you can, but when you move it over, you're moving assets, you're moving credible service. So all those things accrue in teasers at the time of the transfer.
Was she also independently vested in elders too? At the time she
vested
moved?
in elders, yes. She had vested in elders in 2001.
All right, so she was vested in both.
At one time, she had vested in both, and she had credible service sitting in both, and she could have, she had chosen retired from both.
Okay. Now, what about the Register of Deeds fund? That's only for an elected Register of Deeds. Is that correct?
That's correct. That only applies to registers of deeds.
Elected or appointed, or does it apply to assistants or just the elected Register of Deeds?
It is just the elected Register of Deeds, is my understanding. Like,
and it's a supplemental. Is it considered a supplemental retirement?
Yes, it's unlike the other retirement systems. There's no contributions. It's simple. You become eligible by virtue of having been a Register of Deeds for 10 years and retiring from one of the contributory retirement systems like elders.
Was she vested in that retirement system?
And now our position is no, she could not vest in that retirement system because that retirement system was created in a session law back in 1987. And at the time it was created, the legislature said, they have a statute in there that says, we can change this at any time and you cannot vest in these benefits. So it's not possible to vest because the actual statute that created the benefit at the same time said you may not vest in these benefits. And the late decision, I think we cited that in our brief as support for that position.
Thank you.
So I did want to point out, I'm just backing up a little bit to the other forfeiture provision that is in elders. Riddick has spent a lot of time in her brief, and the counsel at argument has spent some time discussing this other forfeiture provision. I wanted to point out and make sure you were aware that the other provision as well has these conditions A1 and A2 that must be satisfied. So that other forfeiture provision only applies to elected officials for enumerated felonies, but A1 and A2, the same conditions that appear in the forfeiture statute that was applied here, those same two conditions have to be satisfied, and there's no other entity mentioned in that statute, so it must be the retirement system that the legislature empowered or authorized to make those two findings.
But isn't the argument that because there were enumerated felonies there, that the retirement system could look at those felonies and determine those two subsections, but because we don't have enumerated felonies in 38(4)A, it gave the trial court the authority, or the authority to find that as an aggravating factor. You either have enumerated felonies or you have a fact finder finding them.
The enumerated felonies, if you look, for example, one of them is one of the enumerated felony federal felonies is making a false claim to the federal government. There's nothing easy about if that were the felony for which the elected official were convicted. You could easily imagine a fact pattern where making a false federal claim has absolutely nothing to do with the elected official's office. So it's not any easier to make the determination that A1 and A2 apply than it would be if it wasn't an enumerated felony, it was some other felony. So I think if we're looking here at the issue of some of these concerns that Riddick has raised, they would be equally pertinent to the elected official with the enumerated felonies as they would be in the context of 38.4A. So the legislature has entrusted the retirement system with making the determination that the felony or the conduct giving rise to the felony is directly related to the employment or office. And by the same token, there's no reason to think they wouldn't have entrusted the retirement system with that same discretion to make those two findings in the 38.4A context. And again, then Part B is simply saying, okay, Part A says the retirement system makes the determination, but if there is an aggravated factor found, then the retirement system should defer, because that's a jury finding or an admission by the defendant. On the other hand, when the aggravated factor is not found, we should have no confidence whatsoever that that means A2 is not satisfied. And of course, this case is the perfect illustration of that. In this case, there's no question, Riddick has never denied that her felony was directly related to her employment.
I have a question about, so she pled guilty to six felonies, correct? And they were not listed in 38.4, correct?
At the time, the relevant time, they had not yet been added. It has since been added.
Okay. And the defendant was on notice, and the state gave notice of this aggravating factor, correct?
Correct.
Yeah. Is there any evidence in our record that there was some reliance on not finding the aggravating factor as part of this plea deal, such that the state took an inconsistent position as to whether the trial court's finding of this aggravating factor was required in order for retirement benefits to be forfeited?
The only thing in the record is pages, I think, 87 to 92 are the sentencing documents, and within the plea transcript, there is a very brief summary of the plea arrangement, but there's nothing beyond that. So we don't know. We know what the plea arrangement was, but we don't know how the parties arrived at that arrangement. So the answers are no. There's nothing in the record but if you look at the plea arrangement, well, I guess I just want to say, my time is winding down, so I'll just say there are so many factors that go into other agendas that go into a plea agreement and in criminal sentencing and prosecution generally, that it just doesn't seem reasonable that the legislature would have intended for the criminal process as a proxy, essentially, for the findings of A1 and A2, which are required for the forfeiture. I mean, I think it's clear if you look at the forfeiture statute that the legislative intent was, if somebody commits a felony directly related to their employment, they should not receive benefits. So then they're going to say, okay, well, we'll just leave this to some criminal proceedings, to see if the forfeiture should actually move forward. We'll leave it to criminal proceedings, and we'll just see if they enter the aggravating factor. I mean, it doesn't seem consistent to me to use a process that's so not necessarily directly connected.
But it seems like at least there's, go ahead, Judge Tyson.
I'm sorry, I didn't mean to interrupt. Judge Collins, you want to go ahead or?
No, I defer to you. Go ahead.
All right. What is the state's position on my earlier question to Mr. Orr about the fact that only a public official stealing money in excess of $100,000 under 1492, that supplies the forfeiture element right there?
Well, and that's one of the points I made in the brief, is that it's so directly connected that there's no question but that A2 was satisfied. The reason that the factor wasn't entered was probably because there was a plea agreement. So is that what the legislature intended? But also, I would point out that you cannot use under the aggravated factor statute, you can't use elements that would prove the substantive underlying offense to also prove the aggravating factor. So it's not clear the aggravating factor could ever have been proven in this case or other cases as well. So it's just not reasonable to think that's what the legislature intended.
So is the state's argument that that language of the aggravating factor under Chapter 15A would apply to a felony not directly related to the person's employment?
No, to find the aggravating factor, it would have to be related. The aggravating factor is just a slightly reworded version of A2, saying that it has to be directly, in order to find the aggravated factor, the conduct for the offense has to be directly related to the employment or office.
So is it more attenuated than someone who's charged with a specific crime where you have to be a public official and steal over $100,000, embezzle over $100,000 in order? Those are the two essential elements of that crime. Do you agree with that?
Yes, and I would say nobody could be convicted of that crime without satisfying A2.
No, not the 1492. 1492 requires someone to be a public official and embezzle more than $100,000. Do you agree that's the two essential elements of that crime?
Oh, yes, that you're the register of deeds specifically, and that you take money intended for the register of deeds and convert it to your own personal use. And it's a felony, a Class C felony if it's over a certain amount. Yes, I agree. And I would propose that there's no question but that somebody who's convicted of that offense has also satisfied A2. I think my time is winding down. I did want to just touch briefly on the constitutional arguments. But as we said, the supplemental funds, there's no vesting in the supplemental funds. And so there's no constitutional issues raised there. With respect to the elders forfeiture, there's no issue with well, first of all, Simpson, Falconberry, Bailey, the earlier cases finding a vested right in the retirement benefits did not address the issue we have here, which is, well, what happens between the time that you vest and the time when you actually become eligible to receive the benefits? Now, what is the nature of her vested right? This is a totally novel question for this court. Even though she's vested, can she still give up creditable service that she earns by working after the time she's vested, but prior to the time she becomes eligible for retirement? And her position is, well, when I vested after 5 years, I then have the right to continue working, commit these felonies, embezzle over a period of years as a register of deeds, but still draw creditable service that would then increase my retirement benefit when I retire. And so our position is, no, when you vested at 5 years, you had the right to continue earning your benefit by working. But that was the state's promise. You, in exchange, had a promise of your own, which was that I will work with good faith, fair dealing, loyal servant. And so she essentially reached her contractual right when she committed the felony. And this felony forfeiture statute just gives that some shape. But that's just basic contract law. If you vest and you retain contract rights, there's a mutuality of promises there. There's promises on both sides, and she's breached hers. So there's no constitutional implications to the forfeiture statute as applied to her. This is an as applied charge, and as applied to her, there's no constitutional issue. And I see that I'm running out of time, so just in closing, I would like to say that what we're asking for is affirm the ALJ's finding that the statute does apply to Riddick, but hold that the transferred service and the sick leave service were both subject to forfeiture. The supplemental funds benefits she was not eligible to receive any of those. And the constitutional issues, there's no constitutional problems with the application of these statutes. And I thank you very much for your time and attention.
Thank you for your argument. Rebuttal, Mr. Orr?
Thank you, Your Honor. First of all, I believe Judge Bryant, you asked a question about the system's argument that the D9 aggravator was some sort of independent or separate device, but the system could still do it. In their brief, and I apologize for not having the direct page where the system admits that if the Superior Court judge had found the D9 aggravator, the system would be bound by it. Yet, on the other hand, they say here, where the Superior Court judge did not find the aggravator, they're not bound by it. And I think that's a totally inconsistent argument. Secondly, on the question I believe Judge Tyson addressed about whether the Register of Deeds Supplemental Pension Fund was vested, we vehemently disagree with the state's position that it's not vested. It vested in Ms. Riddick and anybody else who has 10 years as a Register of Deeds. And if the court looks at the Bailey decision, which I'm sure everybody's familiar with, within the discussion in Bailey, the Register of Deeds Supplemental Pension Fund is included. So simply because the General Assembly tries to avoid a contractual obligation of a vested right through their statutory language, it won't work here, just like it didn't work in Bailey in that line of cases. Secondly, or third, Judge Tyson talked a lot about or asked a lot of questions about 14-92. I would call the court's attention to language in there that says, when such officer shall have received by virtue or color of his office in trust for any person or corporation. So it's a very specific factual circumstance that 14-92 applies to, and there is nothing in this record about the factual circumstances under which Ms. Riddick got this money.
Let me ask you this, Mr. Orr. Isn't that irrelevant because whatever the underlying facts are, she pled guilty to 6 of those charges? So do we even need to re-examine the underlying facts once she's pled guilty to that statute?
I think you do, Your Honor, because the forfeiture statute that the system is pursuing does not list a specific statute. It does not say 1492. It has this broad general application, and so therefore the specific facts are critical, and that's why the General Assembly put the D9 aggravator in there.
Let me ask you this. I want to ask you this too, and this is hard because you're having to argue she's entitled to everything, and then you're also having to argue, against the validity of the order appealed from. So I think I know I think I understand what your claim is. Can you understand why there's error in the trial court's order?
Well, again, I agree with the Attorney General that these are all statutory interpretations. The trial court simply affirmed in a one-pager the decision of the administrative law judge, and we think if you disagree with our threshold issue, the administrative law judge certainly in part got it right on the law, but in part did not. Are
there any findings of facts that are in dispute in the AL judge's order?
No, I would say there are no findings of fact. These are all questions of statutory interpretation.
Now, my question is, are you contesting, are any of the findings of fact in the ALJ's order, are they being contested in any way, the findings of fact?
No, Your Honor. I do not believe we have contested any findings of fact, only conclusions of law.
Thank you.
The question of the 6.2 years of the TASER retirement fund, I would call the court's attention to the system's brief filed on May 28th at page 31 footnote 8, you will see that there is this very inconsistent position about the rights of someone who withdraws time from one retirement system and transfers it to another. So if the court would look at that. Finally, very briefly in closing on the cruel or unusual punishment, Article 1, Section 27 of the North Carolina Constitution uses cruel, it prohibits cruel or unusual punishments without question. Ms. Riddick paid almost $1 million in restitution. She was sentenced to a minimum of 5 years in the women's prison, which she is currently down there in, certainly very, very egregious circumstances. And only somebody in her position who pleads guilty and is sentenced and pays restitution has this added punishment added on. And so I would contend that these forfeiture statutes are certainly unusual and violate her constitutional rights. And so if the court has no other questions, we would rely on our arguments, and we appreciate the court's time.
Thank you.
Any further questions from the panel? If not, we certainly appreciate the arguments of both counsel here today. Thank you very much. With that, we will close court. Mr. Clerk, if you're available, please close us out of this virtual court session. Thank you.
This session of the North Carolina Court of Appeals is now adjourned.
Thank you.